plaintiff and counter defendants in this case, SH Nashville LLC and Uni Nashville LLC, which to keep it short, we'll refer to as purchasers throughout this discussion.
That's an excellent determination.
I kind of liked it myself, frankly. Your Honors, there are basically two issues in this case. One, did the trial court err, as we believe, in dismissing our conversion claim on a Rule 12b-6 motion to dismiss, doing so solely based on the economic loss doctrine, which the Tennessee Supreme Court has made clear applies only in products liability cases, which this is not. The second issue is whether the trial court erred, as we believe, in staying and not allowing my client to take any discovery whatsoever in this case before ruling on summary judgment, not only dismissing my client's declaratory judgment action, but also granting the counter complaint for breach of contract and for recovery of liquid damages under the contract at issue, even though we specifically requested a continuance of that hearing to take certain discovery that we believe was very material and submitted a very detailed supporting declaration in support thereof. I'm not going to get too far in the weeds of the facts because I'm sure that your honors have read the respective briefs, but the short version of the long story is this. My clients contracted to buy what is known as the Hilton Nashville Airport Hotel. I believe it's on Elm Hill Pike, not far from the Nashville Airport. They entered into this contract not long before the COVID pandemic hit. And in the original agreement, they agreed to pay $1.75 million in earnest money. COVID pandemic hits, puts an incredible hold on financing in the hotel industry in particular. The parties worked together at this point. There were multiple extensions, but the seller in this context began to put the economic screws to my client. In short, my client ultimately had to pony up almost $19 million in earnest money, or 23% of the purchase price. 23%.
Well, that was due to a series of amendments, something like 22 or 23, in which your client agreed to add to the amount each time, and in which it was agreed that it wasn't recoverable, right?
Your Honor, I'm not going to dispute the language of the agreement nor the language of the amendments. It is what it is. But part of this is not just the language, Your Honor, and this is what the Supreme Court in the Giuliano case makes clear. Yes, the language of the contract is important, but also, as important, is the public policy at issue. And in particular, Your Honor, it is well settled that an unreasonably large liquid damages provision like this is an unenforceable penalty. And that is our position, Your Honor.
But you agreed to it.
Your Honor, we're not going to dispute. I cannot dispute
I have a little trouble
what the contract states.
How do you get past agreeing to it?
I understand.
Duress? Is it duress? That's your argument?
Among other things, Your Honor.
Okay.
Even if you take the economic duress out of it, Your Honor, you still have the fundamental public policy of the state that applies in the context of liquidated damages. Regardless of what the contract may state, regardless of how it may be characterized, and this is clear in the Tennessee case law, if it amounts to a penalty, a forfeiture, a penalty for breach, a forfeiture of a reasonably large amount of earnest money, then it should be unenforceable as a matter of law. and that is our position.
Counsel, you've identified this time period in which this agreement is going through as a volatile time period in the hotel industry. Why doesn't that volatility read favorably to the seller in terms of we're not exactly sure where hotel prices are going to go in the next month, in the next 2 weeks, and so they're agreeing upon a liquidated damages, they're agreeing upon a provision with uncertainty as to where hotel prices are going to be in 6 months, 4 months. And in each of those extensions, if I recall correctly, they could not look for other buyers. So they can't start developing a backup buyer if the purchaser falls through. And isn't that something where you should be leaning to the expert parties? And these are expert parties on how much it's actually worth to get another 2 weeks, 3 weeks, 4 weeks, whatever the time periods are of the series of amendments that Judge Bennett was asking about.
Your Honor, I'm not going to deny there was uncertainty on both sides. I mean, the COVID pandemic created uncertainty for many industries and many parties. I'm sure there was uncertainty. That is true. But one thing that was certain was this, and that was very material in this context. In the fall of 2020, there was a public announcement of the new on-airport Hilton Hotel, brand new, upscale, flashy Hilton, connected to the airport. In fact, I think opened up earlier this year. And this is what we put in our declaration as a matter of industry custom and usage. When you go and when a big franchise like a Hilton, they build another airport Hilton nearby, they generally tell the franchisees what's going on and give them an opportunity to weigh in. Here, based on that industry custom, my clients reasonably believe that the seller knew exactly what was going on here.
And you couldn't do discovery, you weren't allowed to do discovery to prove it.
That is absolutely correct.
Okay.
That is absolutely correct. And so, Your Honors, I know there's language in the contract that does not work to my advantage. I get it. I understand the arguments. But certainly, we should have been given the opportunity to find out the extent of the seller's knowledge of this on-airport hotel. The result of their failure to disclose was that our lender fell through. We had to scramble to find somebody else. They gave us little to no time to do so. They declared a breach, then sold to another buyer, and pocketed $19 million.
Did the trial court state its reasons for prohibiting discovery?
Not that I'm aware of, Your Honor. I mean, the best I would remember, and I apologize if I'm not going to get this correct, my general memory was after we had the motion to dismiss and the amended complaint again, the court then said we're going to have an answer and a counter complaint and all that stuff, scheduling a Rule 16 conference where we're going to have a discovery plan. I came prepared to have a discovery plan. The seller's attorneys, and once again, I don't besmirch them for doing so. They said, here's this contract, here's this language. It should be clear summary judgment. We don't believe any discovery is necessary. I vehemently objected, making much of the same arguments you've seen here, but the court stayed all discovery. And mind you, again, when they moved for summary judgment, not only do I oppose the summary judgment, but I specifically request a continuance because there are two parts. A, the Supreme Court in I hope I'm not pronouncing this correctly, Giuliano versus Clio. In that case, it said you look not only to the language of the contract, but you look to the circumstances at the time of formation. Okay? In addition, so in general, we've got to look at the circumstances. What that typically means is you have to have some related fact exploration as to those circumstances, which we submit there are a lot of circumstances with the pandemic and the related communications between the parties in that regard, and then specifically, Your Honors, and this is the point we really tried to make hard, is this failure to disclose issue. Here, Your Honors, I mean, we reasonably believe they knew exactly what was going on with this on-airport hotel, didn't disclose it to us, caused our financing to fall through. We were prepared to close. Yes, sir.
Go ahead. I'll wait till you finish your thought.
I'm sorry, I get on a roll sometimes. Go ahead, it's just fine.
The chancellor made a statement toward the end of her opinion or memorandum that says, the claim that the purchasers were suddenly unable to close in October of 2020 because of the announcement of the other hotel after it failed to close multiple times prior to that date, including prior to the COVID-19 pandemic, rings hollow with the court. Now, is that an appropriate statement when you're evaluating a motion to dismiss and a motion for summary judgment?
Your Honor, I have much respect for Chancellor Martin. We were colleagues, friends. I think she's a very good chancellor, but I personally don't feel it was appropriate. And I told her.
Can you explain that?
Yes.
I know I have thinking on it, but I want to hear yours.
We submitted, in opposition to the summary judgment motion, a detailed declaration explaining exactly how this went down. We initially did require extensions, to your point, because of the COVID pandemic and the freeze on financing. But notwithstanding that, my client was eventually able to line up their lender, were prepared to close by the fall of 2020. That's when the announcement occurred. That's when our financing fell through. And that's when further amendments were put in place, personal guarantees, at the point my client is in dire financial straits, taking advantage of the fact that you not only have your financing fall through in light of this failure to disclose, but you also have this increasing risk of loss with almost $19 million there. My clients scrambled, did their best, were not able to meet the very short deadline left, and the seller benefited from that by then selling the property to another buyer and pocketing $19 million.
In the motion to dismiss that was made against your complaint,
Yes, sir.
is not the court required to assume the facts pled in your complaint are true?
Absolutely, Your Honor.
So, in the statement I read, if you remember it,
I do, Your Honor.
read, she's not assuming the truth of those facts, is she?
No.
And in summary judgment, is not a judge supposed to not engage in fact weighing, but just see what the facts show? Is she engaging in fact weighing in that statement I read?
It sounded that way to me, Your Honor.
Okay. Well, I would like your thoughts on that as well when you come up.
Your Honors, I only have a minute and a half left. Can I just reserve that in case we have a little rebuttal necessary?
Certainly.
Thank you.
All right, thank you.
And I apologize, I should have said that on the front end.
Thank you, Mr. Price. Good morning.
Good morning. May it please the court. Sarah Miller with the Nashville Bar, and I'm representing Applee. And I'd like to start sort of where you left off, which is why discovery was not necessary in this case. So it's important to talk about Giuliano when we're talking about liquidated damages. That's the case in which the Supreme Court adopted the current prospective approach to looking at liquidated damages. And in Giuliano, the court does use the term circumstances, but it very clearly defines what circumstances are relevant. So I'd like to start by discussing Giuliano and then discuss some language of the agreement. And I think that makes it very clear why no discovery was necessary here. In Giuliano, the Supreme Court held that the language of the agreements is critical to this theory. And I'll quote, with the court's indulgence from that case, "Under this approach, courts must focus on the intentions of the parties based upon," and it's two things, one, the language in the contract, and then the circumstances that existed at the time of contract formation. And we've spent a lot of time talking about the second piece. This case, the case before the business court, was the rare case where all of the information necessary was within the language of the contract. So Giuliano and the other cases cited by my opposing counsel in this matter deal with cases where a party might call something a penalty or call it liquidated damages or call it severance pay for that matter. And the court's saying, well, just your mere label of this doesn't show us whether it is enforceable liquidated damages or it's an unenforceable penalty. And that's fair. And Giuliano is saying, look at what the parties called it to see their intentions, but also look at the circumstances. But Giuliano is very clear that there are two circumstances that are dispositive to this analysis. And I will quote the case again. The first is whether the liquidated sum was a reasonable estimate of potential damages. And the second is whether actual damages were indeterminable or difficult to measure at the time the parties entered into the contract.
Counsel, can I ask about that second one?
Yes.
And isn't this a circumstance where actual damages are going to be crystal clear? They had a purchase price of X, they sold it for a lower price of Y. The difference between X and Y are there damages? And isn't this a circumstance where we know precisely what the damages are for the sellers?
And that's the retrospective approach that the court actually rejected in Giuliano. And so that's right, it's very easy to tell after the fact, perhaps in a real estate case, what the damages are. And Mr. Price quoted, I think, to the Kimbrough case, which predated Giuliano for that statement. But the fact is the court's looking at the intent at the time. The intent controls here, and none of us can read the future. And so the court wants us to know that if the parties have decided they cannot measure what the damages are going to be in the future, that's why you need liquidated damages. And frankly, the reason for that is so that we don't have this kind of litigation. I mean, I'll go through some of the provisions, and I know we've quoted them extensively in our briefing, but the whole point of liquidated damages is so that the parties have certainty around what their damages will be, and so we don't get engaged in this sort of protracted litigation. And I would also note, the business court is specifically designed to have expedited discovery, and it was in fact the appellants that brought this case to the business court. And I think Chancellor Martin did what she was supposed to do there in determining that no outside discovery could go to those two circumstances. So,
Counsel, does it matter here that these are sophisticated parties? I mean, our purchaser and seller here, this is not an average Joe. These are very sophisticated entities. Does that matter in terms of thinking about this provision and whether it's a penalty or impermissible penalty or not?
I think it matters a great deal, and I'll note that the appellants were represented by a large international law firm in this matter, and they actually noted in the contract that they were sophisticated purchasers of hotel property. So the case, for example, that they cite for economic duress is about a 77-year-old man being forced to sign a contract so he can have a follow-up appointment at a hospital. Those are the kind of cases where economic duress, where unconscionability comes into play. But these are sophisticated parties who very clearly noted in 25 separate agreements, one, what the earnest money should be in exchange for this exclusivity, and two, that was a reasonable amount of damages. And I'd like to just quote a bit from section 6.1. So I'll note, and earlier, Your Honor was discussing the provision at issue, and I think that was probably with regard to the provision in section 6.1. But I want to note that there are 24 provisions after that provision in 6.1 ratifying this agreement each and every time. So when the amount of the earnest money was changed, when the parties modified section 2.2 to change the amount of earnest money, they ratified the original language in section 6.1. And that language is key. It says, quote, "It would be extremely difficult and impracticable, if not impossible, to ascertain with any degree of certainty the amount of damages which would be suffered by seller," that's FWREF, "in the event of purchaser's failure to perform its obligations and to purchase the property." And they even explained their thought process. So I don't believe that that was necessary under Giuliano. They explained it would be difficult, but they actually said why. They said that was due to the fluctuations in land values, the unpredictable state of the economy and of governmental regulations, the fluctuating money market for real estate loans of all types, and other factors which directly affect the value and marketability of the property. And actually, we're here today because appellants are displeased about the other factors that came to pass after they began asking for extensions. But the parties very clearly allocated this risk in Section 6.1, and they ratified it over and over again. And I'll note earlier there was discussion about uncertainty for all parties. So I'd like to just take a moment and talk about what FWREF was experiencing at this time. This agreement was entered into in October of 2019, and it was supposed to close January 3rd of 2020. If that had happened, the $1.75 million of earnest money at issue then would have gone to the purchase price, and the deal would have been completed. But that isn't what happened, and we know what happened shortly after that. So FWREF has every right, under the explicit terms of the agreement, every single time appellants defaulted, to terminate the contract, take the earnest money, and start talking to other buyers. But because they are continually asked by appellants, and this is not me guessing at what happened, this is the specific language of these very thorough agreements, and I haven't brought this as a prop, but I would note this is only the 25 agreements. They're considerably lengthy and detailed. And so instead of terminating the agreement and taking the earnest money and finding a new buyer, they agreed, when requested by appellants, to enter into a new amendment. And they were exclusive that entire time. So they weren't even allowed, under the terms of the agreement, to seek a backup offer during that time, as we watched what COVID was doing to the hotel industry. And so absolutely, as in the Kendrick case, as consideration for that continued exclusivity, they absolutely needed that protection. And the parties were very clear that that's what that earnest money was acting as. I've gone on my own roll, so let me find my place again, please. And I want to discuss Kendrick briefly. So Kendrick is similar in that it involved a purchase agreement and 2 addenda. And the court said you have to look at each of these agreements as the time they're entered into. Now Kendrick was a 12% earnest money payment for 3 weeks of an extension. Here, of course, we're dealing with 15 months, 12 months of which was an extension over the course of the beginning of the COVID-19 pandemic. But the court, the business court here, agreed that you have to look at the intent of the parties as to each agreement as of the time that it was entered. And so doing so, the court found that the intent of the parties at each of those times was that these amounts act as earnest money, and also that they were consideration for this continued exclusivity. The PSA and the amendments show that the Giuliano test is satisfied, and I've talked about the PSA a little, but I'd like to talk a little bit about the amendments as well. So they are replete with language that would be dispositive, and in my first draft I had a 45-minute discussion of those, but I just want to draw the court's attention to 3 factors through these amendments. And the first is that while the parties agreed in October of 2019 to $1.75 million of earnest money if appellants didn't close by January 3rd, the subsequent amendments display the parties' intentional and individualized determinations of what earnest money should be if appellants defaulted after the next extension. So some amendments, the 4th, 5th, and 6th amendments, for example, allowed extensions of time but didn't require any additional earnest money. Now you'll have to do math to see that because they allowed time on the earnest money that was already due, so it looks as though there are payments, but there are no new payments for those. But then in the 7th Amendment on April 3rd, when everyone was realizing that the COVID-19 pandemic was going to have a major impact on the hotel industry, the parties specifically agreed that appellants would not be excused from failing to close due to COVID-19, and that's explicit in Amendments 7 through Amendment 24. And then on June 2nd, when appellants failed to close again, and again, these are just examples of amendments, then there was more earnest money that was required as a result of the next extension. And that extension was from May 18th to June 24th, and that additional earnest money payment was $500,000, and that is 0.625% of the purchase price, not 6.25%, 0.625%. So if we correlate this to the 3 weeks in the Kendrick case, this is a much smaller amount of the total purchase price. And frankly, I don't know exactly what was happening at the time of the Kendrick case, but one can imagine a much bigger impact on the real estate market during that time. So that's the first point I'd like to make with regard to these amendments, is that they were variable and they were considered carefully. Secondly, and I've discussed this before, the parties agreed in every amendment that the language of the PSA was ratified. There was a separate section in each amendment noting that point.
Counsel, the sale here is for the Airport Hilton Hotel. Is there a duty to disclose? I mean, it seems like part of what discovery that's being sought here is what did the seller know with regard to Hilton building another hotel. This hotel wasn't going to continue as a Hilton hotel. Was there a duty to disclose? I mean, if you list what you're selling as the Airport Hilton Hotel and it's not going to be a Hilton Hotel very soon, if the seller's aware of that, was there a duty to disclose here?
There is not a duty, and so I'd like to speak first to what's not in the complaint, in the agreement, and then what is. So what's not in the agreement is a financing contingency, and so that is why opposing counsel has said that that this new Hilton, this third-party Hilton, was important, is because it caused appellants not to be able to get financing. But there's no provision excusing them from default if they can't get financing in this agreement. Those are common in agreements, but the parties chose not to include it here. But there was also no guarantee from FWREF that Hilton would even grant appellants a franchise. I don't think that they are allowed to do that, but clearly in the agreement they do not. So if you look at section 4.2F, it says that the purchaser is not relying on any other representations or warranties than those that are specifically laid out in the agreement. And if you look at sections 4.1 and 4.3, the first defines express representations and warranties. The second says FWREF shall have no liability with respect to the accuracy or completeness of the information that they provide to appellants other than those specifically enumerated representations and warranties. So not only is there no duty to disclose, they actually specifically took any suggestion of such a duty out of the contract. They specifically contracted around that. And then I'll note too that appellants signed 3 more amendments after that date. So when the new Hilton opened, it's not as though there was a lawsuit and they tried to get their money back and cancel this agreement. They continued to sign, and in these amendments, I'll speak to amendment number 22, which is the first one. They stated that FWREF has acted in good faith and continuously been prepared to close on the applicable agreement post the closing date. And the appellants agreed that they shall not be granted any further extensions of the closing date for any reason. And again, these are sophisticated hotel companies, and you will see at length in Mr. Wu's declaration, he talks about how sophisticated they are, how much experience they have, and they were represented by Proskauer Rose, at least with regard to the original PSA. All right, so we've talked about the liquidated damages provision, and with the 1.5 minutes I have left, I would like to talk briefly about the economic duress argument. As discussed already, the case law is really an opposite here with regard to economic duress, and the highlight is not only that these are sophisticated parties who made clear agreements, but also that economic duress is something that one party applies to another. So to be legally cognizable and to protect a party, if the financial circumstances of the other party are not good, it must be the case that those financial circumstances were caused by the party who is our party, the defendant in the case. And that's just not the case here. So there were externalities that affected both parties here. And Chancellor Martin noted that not only were appellants in a position where they had to pay earnest money, but FWREF, as a result of all of these extensions, was in a position where it could not take advantage of pre-COVID and pre-New Hilton market conditions. And that's exactly what these agreements were intended to protect. So the parties allocated the risk here. Frankly, I don't think these agreements could have been any clearer under Tennessee law. And so for those reasons, we would ask you to uphold the business court's decision and to honor the parties' contracts.
I would like to hear you discuss my question to opposing counsel about Chancellor Martin's comments about the reasons ring hollow, and whether that is contrary to the standard for reviewing a motion to dismiss and weighing the evidence contrary to summary judgment standards.
So, Your Honor, in our briefing, we tried in determining that we'd like not to seek discovery, we were very careful and thoughtful about the fact that it seems clear to us from the agreements that no discovery is needed. And so we didn't get into any of those issues. It does not matter for purposes of your decision to get today whether FWREF knew in advance about this hotel. It does not matter if appellants had some secret reason that they were deciding to continue to move forward with these agreements. And it really doesn't matter if it's true that they could have gotten financing at that time. All of that is irrelevant because Giuliano is very clear. If those two circumstances are present and the agreement shows the intention of the parties that the earnest money is intended to compensate for breach, that's the end of the analysis. And so I take Your Honor's point that that seems like a comment perhaps unnecessary to that ultimate determination, but I would argue that that's exactly what it is. It's just not necessary to the determination that these agreements and the parties' intent should be honored.
Okay.
Thank you very much. Since we gave Ms. Miller a little extra time, let's give the appellant 4 minutes for rebuttal. Okay.
Thank you, Your Honor.
And Mr. Price?
This court made clear in Homestead that when it explicitly extended the duty of disclosure of material facts to real estate transactions, there can be no doubt as a matter of law in that regard. And in particular, I would note it in the V.L. Nicholson Tennessee Supreme Court case. The court made it clear that even if a liquidated damage clause in a contract were otherwise enforceable, a contracting party will not be allowed to recover liquidated damage where that party contributed to the delay or non-performance at issue. That is Tennessee Supreme Court V.L. Nicholson. Here, as reflected in our detailed declaration, notwithstanding the COVID-19 pandemic, the purchasers would have been able to close on the Hilton Nashville Airport Hotel in the fall of 2020, but for the failure of the seller to disclose the plans for the new on-airport Hilton Hotel and seller's failure to disclose in that instance.
Ms. Miller says you contractually agreed that the seller had no duty to disclose.
I respectfully disagree, Your Honor. I get it. They've padded the contract with favorable language. I understand that, and the language is what it is. I'm not going to argue otherwise, but the fundamental duty of disclosure exists as a matter of law. And in this instance, not disclosing the new on-airport Hilton Hotel, which, as detailed in our declaration, had a $20 million effect on the value of this hotel, clearly material. Mind you, Your Honor, the cover page of the original agreement is for the Hilton Nashville Airport Hotel. The hotel itself is defined as the Hilton Nashville Airport Hotel. I don't see, when you look at that and the underlying duty, how you can say you don't have a duty to disclose in this instance.
Under the agreement, did the seller have a duty to assure that Hilton would grant your clients the franchise?
I'll be honest with you, Your Honor, I don't remember the exact language on there.
Typically, the franchisor controls that.
I understand, Your Honor, but here they were buying the Hilton Nashville Airport Hotel. And that's on the cover page, that's how it's defined. At minimum, shouldn't you have an opportunity to disclose that? Or should you have a duty to disclose that, and my client the opportunity to know that going into this? I would say absolutely. And at minimum, Your Honor, we should have had an opportunity for discovery on that point. And that's sort of where I am on that point.
Counsel, how did it affect, excuse me, how did it affect the ability to close in this case? I mean, the hotel was going to be $79 million, whatever the price tag is, and even though it's not a Hilton, its price tag $79 million. That wasn't going to to decrease. So how did non-disclosure affect the ability to follow through with the sale? I mean, I know the lender backed out, but was there another lender that was essentially going to be ready, waiting in the wings, or that you could have lined up in the wings? Have you asserted those facts?
Yes, in the declaration, we made it clear, A, we had lined up this particular lender, they were prepared to close. And the only reason they did not was because of this on-airport hotel public announcement, and they backed out. We then had to scramble. Ultimately, we were able to find another lender, but by that time, the seller had already entered into contract with another buyer. So A, they wouldn't sell it to us, and B, they refused to return our earnest money.
All right.
And I think my time's up, so I have to better stand on my prior arguments and briefs. Thank you for your time, Your Honors.
All right. Well, thank you, Mr. Price and Ms. Miller. You have given us a lot to think about. We'll take this matter under advisement. That concludes the